I learned how to read in kindergarten. But I ignore when parents remind me that appeals are not allowed regarding termination of parental rights, because trial does not exist under the law. Nor does it exist regarding fact findings. I do fully understand that this court is a court of law, and that judges are bound by the law. But I am eager to impress King County Superior Court employees, so I will do anything they tell me to do, including postpone court hearings, pretend I don't have paperwork, that I do have. Also, they can get a reaction out of these parents. This makes me feel great inside. I never think about the children, because I don't care about children. I would rather know that they are being forced into illegal adoptions, than go home with their biological parents. I stand for justice, and to me justice is ignoring the written law, and pretending like court rules are the law. Pretending like parents aren't sending me documents, when I have them already. This brings me great joy and pleasure. I get paid far too much, to do absolutely nothing for these parents. For a few years Ms. Zayas has been asking me to appeal the court hearings in her children's cases every 6 months. I repeatedly deny her request to appeal. It's in my job description to read the documents that Ms. Zayas sends in, and I can see that she did not sign the order, and that is why she is appealing. Because it's an agreed order, that she never agreed to. I pretend as if we have the power to force her into a dependency, and ignore her. I reply by sending her long letters, that make absolutely no sense, but explain that she is not able to appeal. Because the Supreme Court is going to force her child into an illegal adoption under absolutely zero laws. I can see in the revised Code of Washington, that there is no statutory authority governing an appeal to a termination of parental rights. I also see that there is no statutory authority governing an appeal to a fact-finding trial. From what I understand after reading the law, there's no such thing as a fact-finding trial. But I follow court rules and I don't follow the law. Because my court rules are above the law, and if we don't force parents to comply with child protective services, then their children might be harmed, and we're doing this for the children. But primarily only Caucasian children that don't have brown eyes.
Social worker asked how she feels about possibly living with the foster family forever. The child said it would be good, but she would miss her mom, and again stated that Kent is far away. When social worker began asking the child questions about permanency, she became less talkative and eventually stopped answering questions and or was very quiet. Social worker stopped asking questions about permanency and switched to asking about school and what she has been doing at school. The child talked about the Valentine's Day parties she has been having in her class. Worker called Marcel after Miriam mentioned wanting him to be placement/the adoptive option for the child. Marcel answered the phone, and the worker introduced herself and her role. The worker explained to Marcel that she got his number from his mom, Miriam, and was calling to speak about her proposal that his sister be placed with him. The worker asked Marcel how he felt about that. Before answering, Marcel asked the worker why his sister can't just live with his mom, Miriam. The worker explained that Miriam is required by court order to engage in and show progress in services, and until she is able to do that, his sister must remain in out-of-home care. Marcel replied, "Okay." Worker then asked again how he felt about his sister living with him and him being her guardian. Marcel replied that he is willing to do it. The worker explained that his sister is and has been doing really well in her current placement. The worker then asked Marcel when he is expected to graduate high school and what his plan is in the near future. Marcel reported he would be graduating high school on June 24, 21. Following graduation, he plans to get a job and move into an apartment closer to his mom. He went on to say he will get a 2-bedroom house if he has to.
Case note 1 of 1 entered by Emily. Pleasure date entered January 6th, 2021. Time entered 11:08 a.m. Worker sent a text to the caregiver regarding the child's enrollment in the Christian school, following a formal complaint made by Miriam. After sending the text, the caregiver called the social worker to discuss. The caregiver shared her concerns with the possibility of the child being forced into virtual schooling, as she strongly feels that is not in the best interest of the child and would actually be causing her more harm and trauma. The caregiver shared her frustration in feeling as though a step was missed because she was previously told at the time of decided to enroll the child in the Christian school that due to it being in the best interest of the child, there would not be an issue. Caregiver stated she will talk to whoever she needs to talk to in order to ensure the child is able to continue with in-person schooling. With that being said, The caregiver also reported that where the child attends school is a non-issue, as long as it is in person. The caregiver strongly believes that forcing the child into virtual learning will pull her back to where she was academically and possibly even further behind. The caregiver asked the social worker if this is a conversation she should have with the social worker's supervisor. The social worker stated that might be a good idea given the social worker does not have all of the information regarding previous conversations had about this topic prior to getting assigned the case.
The caregiver reports the visits have been changed from 5 visits a week to 3 visits a week. From the visits, she will often tell the caregiver that she has had candy and she does not speak of any other foods being consumed. The caregiver reported that on will say she is scared of her mom, but the caregiver is wondering if she may be using that word, scared, because she doesn't quite have the vocabulary to say that she doesn't want to go see her mom. Caregiver needs. The caregiver reports no needs at this time.
This supervisor received a phone call from Miriam. Upon answering the phone, she immediately began speaking about the visit supervisor ending her visit early today. She explained that he ended the visit because Miriam had been about not calling the foster parents mom and dad. Miriam went on to explain that kids have never been allowed to call their foster parents mommy and daddy, and they should only be called by their first names.
February 14th, 2021 Julie DeCamp. Case note, page 14. Permanency. Plan remains return home to mother, however as the child has been out of home for almost a year, worker is planning towards adoption, due to lack of progress by mother. Dependency will have been established for 6 months in April 2021, worker will plan to have termination of parental rights petition complete and submitted to AAG. The current foster home is an adoptive resource for the child. February 16, 2021 Julie DeCamp. Case note, page 18. Miriam then got into talking about how the foster parents aren't brushing the child's hair. Social workers stated that they are brushing her hair after her nightly baths. Miriam insisted they have not been brushing her hair and then explained the same thing happened to her older daughter who now has to have short hair because her foster parents never brushed it. Supervisor shifted the conversation to talk about services. Miriam jumped right into saying that she is no longer going to do any of the court-ordered services. She also made several statements that she does not have to do services because she is appealing the dependency case. The supervisor tried to explain and reiterate to Miriam that even though she is trying to appeal, until there is a ruling on her appeal, she is still required to comply with the current dependency order. Miriam claimed throughout the conversation that she has done them all. The supervisor asked Miriam if she could explain what her services are to determine if Miriam had a clear understanding of her services. Miriam claimed to know what her services were.
I have this really wonderful idea. Why don't we let all the juveniles out of juvenile hall? We can just empty out the juvenile jail completely, okay? Then we will legalize all drugs, and allow people to do these drugs on the sidewalk, in front of everybody. Then we will create a ton of youth shelters, only for ages up to 25 years old. Make them serve cereal every morning, and allow these young people to stay in these shelters for free. They could even keep their boyfriend, or girlfriends in there with them. We will not drug test these kids, and pretend it's because we care about them. When really we are just keeping their bodies warm, for harvesting their organs. Let's stop holding nonviolent offenders in the King County Jail. That means you will have to release 90% of the jail population. The more organs the merrier. Let them all out of jail, and pretend that you love them and that's why you're doing it. Because we feel like they deserve freedom. Before you let them out, make sure and give them Suboxone, so they stay addicted until they are released. Do not offer any type of drug assessment while they are in jail either. Have the legislature make a law that says, you won't get into trouble if you kill your friends with fentanyl. These people are waiting too long to call an ambulance, then their organs are no good after an hour. We need them to call right away. Even though there is no way we can make it anywhere in 5 minutes, just pretend until you get there. Let's ask Congress for a bunch of money, and pretend like we sued the makers of fentanyl for it. Let's pretend we're going to use that money to help people recover from fentanyl, but instead we will just keep the money for ourselves. I'll never pay for anybody's drug treatment, even those who have been sentenced by a judge to go to treatment. Make sure and set the price of the blues to $2 a piece. We want to make sure they can afford it.
I need help. I was walking down the street, and I found this guy, but I don't think he is alive anymore. He looked asleep, but as I got closer, I could see he wasn't moving. Now that I am right next to him, he is not responding, and he is freezing cold. He looks like he's gone, sir. Please send somebody. I am on Jackson Street, downtown Seattle. The address is 614.
Do you know how to do CPR? Do me a favor, I can guide you through the process if you need. Did you check his pulse? Don't worry, I know some real good paramedics that can revive anyone, no matter how long they have been dead. I will send them right away. Do me a favor, are there any cameras around? Go ahead and pretend you are doing CPR until the medics arrive. Will you do that for me?
What? I don't think I can, sir. He is long gone. Look, just please send someone fast. I don't want to be here for long. If the person who did this to him is anywhere around, then I might not be in a safe situation. Are you going to send the cops or what? What is taking you guys so long? His eyes are open, sir. He is definitely not here anymore.
Look, we don't come to overdose calls. That is not in our wheelhouse. A ridiculously large fire truck is on the way. That will likely not fit in the alley where you are located. Don't worry, we will get his heart beating long enough to take him to the hospital. Then the doctors will put him on a ventilator, and if his ID says he is an organ donor, then his family will have no say in whether or not the doctors pull the plug. If they refuse, the hospital will just sue them. Regardless, they need organs, so stay with him until they arrive.
Is this the police? Hey, I just ran into this guy who looked like he was freaked out. He was breathing like he had been running and told me that he thinks he just killed someone by giving them fentanyl. I am downtown near the stadium in Seattle. He was about 5 feet 5 inches. He had red hair and it looked like he had a gun in his waistband.
That is wonderful. Look, do you know how much time we would have if we ran around chasing people like that all day? None. We don't uphold the law. Because of this, there are now far too many people killing each other with that stuff for us to save them all. In fact, we decided that it would be better to go ahead and steal their organs instead. We didn't put poison on the controlled substances list for no reason. Thank you for being a good Samaritan and all, but do us a favor and don't call unless you have an actual crime to report. That, my friend, is not a crime, it's a suicide.
Names were altered in the following pages of Discovery. Julie DeCamp illegally recorded this mother audio without her permission during their visit. Nobody can write that fast. But they got every second of detail.
Time entered, 10:48 a.m. Social worker called Sarah's school to provide them with contact information for her after being made aware by the foster mother that mother had emailed the school. After providing contact information, the social worker asked if it was possible for a staff-wide email be sent out stating not to give any information or reply should mother send an email to any given staff member in an effort to access information on Sarah or the foster family. The contact at the school mentioned she had already done that earlier in the morning after receiving a call from the foster mother stating mother was able to locate Sarah's school. The contact at the school also agreed to forward on any other attempts at contact by mother. Safety threat number 5 is active. There are significant concerns about mother's out-of-control behavior related to her substance use and untreated MH concerns and how it impacts her ability to provide a safe environment for Sarah. Social worker and supervisor completed an updated safety assessment which verified safety threat number 5 and the out-of-home decision. The dependency FF trial occurred and dependency was established. Mother is appealing the finding of dependency. Social worker will follow up with AAG about the appeal process and timeline. Judge entered an order on December 10, 2020 prohibiting mother from sending derogatory communications to the court and legal parties. Child Sarah, no CASA/GAL. She is 6 years old and placed in licensed foster care. She is attending a private school and is in kindergarten. She has a small class size and she likes the teacher. She goes in person to school 4 days a week. She does well with school. She really likes reading and math. She reads with the caregivers daily. She 3 good friends from school. She is in therapy through friends in youth every other week. She has warmed up to her counselor and likes going now. Sarah's has some behaviors after visits being out of control, but she is able to calm more quickly. Foster parents have a routine of checking and providing her space to talk if needed about her feelings. Sometimes Sarah wants to be held all night after returning home from visits. Sarah does not really talk with the caregivers or social worker about her mother. She is up to date on medical and dental, no health concerns. Overall, Sarah is doing well in the home. Sarah and the foster parent's child get along very well. Visitation, 2 visits a week for 2 hours supervised. Visitation is in person at the DCYF office in Kent. Olive Crest has a contracted provider facilitating the twice-a-week visits. Social worker observed a couple recent visits and noted that mother often interacts with the VS and Sarah plays independently. VS has noted some continued concerns about conversations mother has with Sarah. Mother, attorney, pro says she lives in Kent and has an apartment, Section 8 voucher. She is not employed at this time. The dependency trial has now completed and she was ordered to engage in the following services: 90 days of UAs, open referral at Stop in Kent. Mother refuses to attend any more UAs. She insists that any positive results are due to her medications. Social worker reached out to Court and Lab and they reported the results are not consistent with mother's medication, drug and alcohol evaluation. Mother attended an evaluation in April 2020 at Stop. Following her positive UAs they changed the recommendation to inpatient. However, she reports that since she never used drugs she can't go to treatment and refuses to do the recommended services. Psychological evaluation with parenting component, social worker made referral to doctor. And the initial appointment occurred on December 4th. They completed the testing and interview. Service letters are sent each month via email and in person. Mother folds up the letter and refuses to accept the services are ordered because of her appeal. Mother was seeing a therapist at THS but she rescinded her ROI for the department to talk about her. She continues to file lawsuits or threaten to file them against anyone involved in the case. Mother continues to be extremely fixated on race. System is racist against white women, forgery by all the legal parties and the court. She becomes quickly escalated in conversation and is not able to work productively with the department. Education/development. School is reportedly going really well and Sarah physically attends school. Caregiver reported that there are 6 kids in class, total. When talking with Sarah privately, she reported she enjoys school. Caregiver reports Sarah loves to read and is showing rapid improvement in her growth at school. Sarah has to read for 10 minutes after school and enjoys reading to the caregiver. Sarah is really good at reading books from memory, especially books with rhyming themes. Caregiver shared that Sarah is sight word heavy but is starting to sound out words, which is a big improvement, and feels her reading capabilities will continue to grow with this new skill. Caregiver reported Sarah loves her teacher and the teacher loves her. The teacher is still reporting that honeymoon phase with Sarah is coming to a close as Sarah is starting to be more open about sharing her opinions and pushing back a bit on instructions. This is not impacting the relationship between the teacher and Sarah. She is still very well liked by her teacher and classmates. Connections. Sarah attends twice-weekly visits with her mother at the CA office for 2 hours each. Her older brother, John, will sometimes occupancy mother to the visits. These visits are supervised. Caregiver has noted that Sarah's previously reported behaviors following visits have vastly improved and she is able to come back into the home and assimilate much quicker without much frustration or physical reactions. Sarah reported visits are good and that she plays with toys. Social worker asked Sarah if she plays alone or with her mom during visits. Sarah replied, both of those things. Social worker asked Sarah if there was anything she didn't like about the visits, in which Sarah replied, no. Caregiver reported that Sarah has never asked her when her next visit is and rarely if ever asks about her mom or her brother, John. Caregiver reported that things are going well, and she has seen a huge improvement and comfort level increase with Sarah. Caregiver reported she has seen more confidence in Sarah and an increased feeling of security within the family. Caregiver stated that her behavior is continuing on an upward trend. She also reported that Sarah is becoming more flexible and adaptable. Caregiver has noticed that when there are weeks without visitation, Sarah is observed to be level-headed, happy, and like a kid. There is primarily an escalation in behaviors surrounding visits and post-visits. Caregiver stated that most of the time, Sarah is sweet, and she is able to self-regulate. Caregiver reported that there has been a much more established sibling relationship between her daughter and Sarah, which includes more bickering between them, typical of any sibling relationship. This has been observed to be more relevant in the afternoon following school, with both girls are tired. On the contrary, weekends were reported by the caregiver to be a completely different story. Sarah and the caregiver's daughter were reported to play very well together in a very organic way. Caregiver reported that they rarely turn the TV on for Sarah and their daughter during the weekends due to how well and how much they play together. Caregiver plans to get her Sarah's hair braided during the winter break. Date entered, December 30th, 2020. Time entered, 6:02 p.m. This supervisor received a phone call from office manager. She reported that mother was upset and yelling that she needed a bus ticket. This supervisor called mother and explained that anytime she is requesting assistance, it needs to be through this supervisor or social worker pledger. This supervisor explained that all items, including bus tickets, need to be justified and signed out by a social worker. The front desk staff cannot provide them without social worker authorization. Mother reported that she has a flat tire but will be getting it fixed and need a bus ticket today. This supervisor agreed to provide a one-time bus ticket due to the next week she would not get more. As yesterday, December 29th, the supervisor provided her with $50 gas card to assist her with getting to visits. Social worker Hake provided mother with a bus ticket. At 4:05 p.m. mother called this supervisor back. She began talking about her views on the case in general and stated that the case is based on forgery, that Sarah was taken illegally. This supervisor attempted to focus the conversation back to the transportation situation and confirmed that mother had a bus ticket to get home. Mother talked about her lawsuits and specifically was focused on the federal case, explaining that the federal judge believes her about the forgery because the case was dismissed. She believes she will be a millionaire from the lawsuits and that everyone in the Kent DCYF office will lose their jobs. This supervisor reminded mother about the SPM tomorrow at 10 a.m. and encouraged her to participate. This supervisor explained the purpose and talked about wanting to discuss the psychological evaluation recommendations. Mother talked about Dr. being a liar and stated that she will not come to the meeting or participate in any services. She stated that she doesn't have to do services because the whole case isn't real because of the forgery. This supervisor tried to be very concrete and direct by explaining that the case is valid and if she continues to refuse to engage in services then the case will not lead to the outcome she is hoping for. This supervisor talked about how the psychological evaluation seemed to make some recommendations that could really benefit mother. This supervisor explained that Dr. S. report is highly consistent with what this supervisor and social worker pledger observe. Mother often spoke over this supervisor and disagreed with all statements made. This supervisor offered to resend the call-in information for the meeting tomorrow and ended the call as mother continued to become escalated and the conversation was not productive. Date entered, January 5, 2021. Time entered, 10:18 a.m. This supervisor provided transportation and supervision for today's visitation between mother and Sarah. This supervisor was late to the visit, arrived at the office and visit began at 1:25 p.m. Visit still would 3 hours, ended at 4:25 p.m. Sarah greeted mother and then said presents. She helped her mother carry the presents in the visit room. Sarah began opening the presents. She got the following gifts from mother: kid-sized umbrella, Barbie mermaid, makeup/nail polish, Barbie, coloring books and crayons, and a tablet. Mother let Sarah know the tablet will be for her to play with during visits. Sarah asked mother if the gifts were all from her. Mother said, "Me and Santa Claus." Sarah played with her Barbies. Sarah said, "Mommy, you don't believe in Santa Claus?" Mom said, "How come you don't believe if Santa Claus gave me some of the presents?" Mom asked if Sarah wanted to watch a movie. Sarah seemed entertained with her presents. Mother offered a sandwich to Sarah. She said, "I don't like sandwiches." Sarah continued to play and Sarah opened up the toys she got. Mother and Sarah they sat next to one another on the couch. Mother helped Sarah get stickers off a sheet and Sarah tried putting them on her ears and then Mom tried to put one on Sarah's forehead. Sarah said, "Stop, Mom." She seemed annoyed. Sarah again told Mother to stop. Mother laughed but then stopped. There was a youth in the DCYF lobby who was yelling. Mother said, was that a kid? This visit supervisor, vs, nodded. She said, I go out and beat, and she laughed and then said, I know I can't. Teenagers are tough. Mother got out a coloring page and colored at the table. Sarah played on the floor with her Barbies. Mother said, how is that god of yours doing anyway? Sarah did not respond. Mom asked if it was okay to put on a movie for 20 minutes. This vs said yes. Mother set up the DVD player and talked about how John is currently in Texas right now and she has not yet heard from him since he arrived. Sarah let Mother know she needed to go to the bathroom. Mother, Sarah, vs all went to the restroom and Mother assisted Sarah with washing her hands. When returning to the visit room, Mother started the movie, Super Furball. Sarah sat with Mother on the couch and ate Airheads candy. This vs stepped out and another social worker covered for approximately 15 minutes. Mother asked Sarah if she gets enough food in the foster home. Sarah said yes and said, I ate all my breakfast today. Mom said, oh good. Mother painted Sarah's toenails and Sarah helped. Mother made a comment based on something said in the movie that was playing. She said to Sarah, don't be friends with people who make fun of you. No one makes fun of you, right? Sarah said yeah. Mother said, wait, what? Who makes fun of you? Sarah said no one. Mother said, okay good, you tell them you have a big brother if they do. Mother asked Sarah if she could brush her hair. Sarah said no, I don't like it when you brush my hair, only when brother does it. Mother put Sarah on her lap and Sarah was giggling and wiggled away from Mother. She jumped off the couch. Mother told her to be careful. Sarah ate more candy. Mother told her it was the last piece of candy until the end of the visit. Sarah grabbed a cookie Mom brought and began eating it. Mother and Sarah watched the movie and Mother made comments to Sarah about the movie. Sarah ate a few more bites of cookie and then gave it to Mom. The movie was turned off at 2:40 p.m. Sarah then brought the tablet over to the couch to play with. Sarah noticed that it was getting dark outside and she asked Mom if it was morning. Mom talked about how it is the afternoon, but it feels like a long day because she is on moss break and she is used to being in school. Sarah played independently on the floor. Mother was trying to set up the tablet and get it Porto connected to Wi-Fi. Mom called for Sarah to come over and Sarah ignored and continued playing. Mom again said Sarah's name and Sarah said, I heard you, Mom. While Sarah continued to play, Mother told Sarah that she should start asking when she can come home. Sarah said, they don't know when I am coming home. Mother asked Sarah to come over to her and Sarah said, no, I don't want to. Mother started driving a remote control car and had it over near Sarah and her Barbies in an attempt to engage Sarah. Sarah watched the car and then yelled, stop, when it ran into her toys. Sarah appeared increasingly frustrated with her Barbie clothes. Mother offered to help and Sarah said no. Sarah ripped the strap off the Barbie dress because she could not get it to fit correctly. Mother said, you know who you remind me of? Sarah did not respond. Mother said, me, you remind me of me. Mother then continued to talk about love and anger and would then address Sarah. Sarah did not respond to these comments. Sarah continued to express frustration with the Barbie clothes. Mother tried to hold her and pulled Sarah on her lap. Mother told Sarah she seemed angry. Sarah wiggled away from Mother and said no. Mother told Sarah to be nice to her mommy. Mother continued to speak saying, why? Because mommy is on your side, every day. Sometimes I think about you at night, wonder if you were thinking about me, and then I sleep. Sarah did not respond to any of these statements. Sarah continued to try and get her Barbie clothes on correctly while Mother painted her own nails. Mother commented that Sarah appeared cranky and tired. Sarah said no, I'm not. Mother fixed the Barbie dress and appeared momentarily calm but then continued to show her frustration about the dress not fitting right. Mother fed Sarah a bite of cookie. Mother asked to take a photo of Sarah but Sarah said no and ran away. Mom pretended to sleep. Sarah walked over and sat with Mom and allowed her to help with the Barbie hair. Mom said Sarah is being cranky today. Sarah said no, I'm not. Sarah yelled no. Mom said, why are you so mean today? Mom said, you know why. Sarah continued to say no, I'm not. Sarah said to Mom to stop being silly. Mom said you stop being angry. Sarah growled. Then they giggled for a minute. Mom continued to say, why are you being so mean? Mom said she was going to throw the doll in the dumpster. Sarah yelled no. Mom said it's just a doll, and Sarah said no, it's not. Mom, she was going to write a note for her to take home. Sarah yelled no. Mom and Sarah argued back and forth, then Sarah began crying and then Mom hugged her/comforted her. Sarah appeared accepting of the comfort. Mom said you don't even know it, but you are sleepy. Mom explained that it is like when a baby is sleepy. Sarah asked Mom to stop being mean to me. Mom said no, I wasn't. Sarah said but you were. Mom said she was sorry. Mom asked Sarah, did someone hug you today? Sarah didn't answer. Mom said, honey, you're perfect. Sarah said, no, I'm not. God is. Mom said, we live forever. Sarah said, no, we don't, you never read a Bible. Sarah then said she never read it before either. Mom asked if Sarah is getting along with her sister and then asked if her sister is still hitting her. Sarah said she doesn't. Mom said she used to and Sarah said no, she didn't. What did you ask for, Moss? Sarah didn't answer. Mom said, you are mean today, I don't know what your problem is. Sarah said, stop being mean to me. Mom said, you are mean, look at the way you are talking to me. Mother said, she's always mad at me every visit. Probably because they don't tell her anything. They don't tell you how your life is going to be. I don't want to tell you. Ask me and I'll tell you. Sarah said no. Mother continued talking. It appeared she was speaking to Sarah, but then the VS, she said, I can't ask you what their names are, look, I didn't do it. What do you mean? Exactly what did I do? She used to skip walking to Safeway with me. It's a natural happiness to skip. If you watched the videos of her when she was with me, she was a different person. Apples and oranges. Sarah ignored Mom, continued to play with Barbies. Mom laid on the couch. Did you tell them about all the other planets and stars in the sky? Sarah said no. Remember what I taught you about the other planets? Sarah said no. Do you hate me? Sarah said no. Mom said quietly, you know, I felt the same way. They conditioned all of my children to hate me, said this quietly, and Sarah was playing independently and did not comment. You know, Jasmine believes in God, she was brainwashed a long time ago. Sarah asked Mom for help taking the mermaid tail off her Barbie. Mother helped and Sarah went back to playing independently. Mother was on her phone and the tablet. Mother asked this VS if we talked about something on the car ride. This versus said no. Sarah was mostly quiet on the drive. Mom continued to be on her phone. Sarah played quietly and independently. Mom then showed Sarah a video on YouTube. Mom asked if it brought back memories and Sarah shook her head yes. Sarah chose different videos of Barbies playing on YouTube. Mom said she's not used to these long visits, she probably needs a nap. Sarah watched videos and laid on Mom. Mom told Sarah, don't stress yourself out, think happy thoughts. Mom cleaned up while Sarah watched YouTube. Sarah laughed at the YouTube. Mom commented that it is funny and she hasn't watched it in a while. Sarah started falling asleep on the couch, she was yawning. Social worker gave a 10-minute warning to end a visit. Mother and Sarah hugged and said goodbye. Visit ended at 4:25 p.m. Date entered, January 6, 2021. Time entered, 9:34 a.m. This supervisor provided transportation and supervision for today's visitation between Mother and Sarah. Visit was 2.5 hours long. Visit began at 1 p.m. at the Kent DCYF office. Sarah greeted Mom and told her she had presents for her. Mom was excited and asked if she wrapped them all herself. Mom commented on Sarah's hair and said it was so pretty and soft. Sarah helped Mom open all the gifts. Mom was thankful and appreciative for everything. Sarah said she got them all and picked them out. She said her foster mom helped her. Sarah got her perfume, nail polish, lotion, and a candle. Mom commented that everything smells good. Mother said thank you to Sarah and said it was nice of the foster mom to help. Mother brought a couple bags of items with her to the visit. Sarah looked through all the bags. She found balloons and began blowing up a balloon and then letting it go. Sarah went through the toys Mom brought, Barbies and a Nerf gun. Mom said don't shoot me or MS Julie. Sarah said I won't and shot the Nerf darts at the snowflakes on the walls. Sarah ate sweet tart candies. Mom again commented on Sarah's hair and said it looks beautiful. Sarah sat on Mom's lap and played on the tablet and watched a YouTube video. Sarah ate Twix and dipped sweet tarts in frosting. Mom told Sarah she caught the bus today because she had a flat tire. Sarah played with remote control cars. Mother picked up the Nerf darts and reminded Sarah to pick them up after using them. She continued to watch YouTube. Mom talked with Sarah about Cecilia and said she has straight hair and 2 teeth. Mom said she was in foster care when she was a kid but she was older and was being bad so her mom kicked her out. Sarah asked her if she was sad and missed Mom. Mom said yes I did. Sarah kept eating mini Twix candy bars. Mom told her only one more but Sarah kept opening more. Sarah laughed when she ate another piece. Mom laughed too. Sarah shot darts and Mom told her not to shoot them near this versus redirected her to shoot things on another wall of the visit room. Mom said she misses Sarah when she doesn't see her for a while. Mom asked about her Barbies and Sarah said that she gave them away. Mom said who took away your Barbies? Sarah said no one, I gave them away. Mom said I don't want anyone taking advantage of you and I want to make sure they weren't taken from you. Sarah said they weren't. Sarah told Mom that they got 2 new puppies. She described them and Mom asked if the helps take them outside. 2:07 p.m. Santa Claus isn't real. Sarah said yes he is real. Mom said no Steve is Santa Claus and Sarah said no he is an elf. They laughed. YouTube continued to play. Mom told Sarah they need to make their own YouTube channel sometime. Mom asked if Sarah kept the umbrella and she said yes. Mom told Sarah she gets to see her tomorrow. Mom talked with Sarah about New Year's and asked if she will be staying up until midnight. At 2:20 p.m., turned off YouTube. Talked about bracelets with days of the week on them. Mom told Sarah she got a new toy box for her and said all the new toys are going to go in it and then she will give away the old toys. Sarah was upset that Mom would give away her toys. Mom explained that it's only the ones she didn't play with. Mom said the guinea pigs are turning yellow because they are sitting in their pee. Mom said she isn't going to touch them. Sarah continued to eat sweet tarts. Mom told Sarah that Lola has a hard time breathing so she needs a breathing machine. Sarah asked questions about it. Sarah sat on Mom's shoulder. Mom commented that she likes the onesie Sarah has on. She said she got it from us. Sarah and Mom were fighting and laughing. Mom painted Sarah's toenails. Sarah blew up a balloon and let the air out over and over. Mom reminded her to be careful. Sarah put on lip gloss that she gave to Mom from us. Mom told her not to put too much on. Sarah sang Ma's songs. Sarah asked if it is normal for her lips to sting from the lip gloss. Mom said it's probably because her lips are dry. Bathroom break for Sarah at 2:56 p.m. VS told Mom and Sarah 30 more minutes. Blew balloons and tied them closed. Sarah shot balloons into basketball hoop. Mom cleaned up while Sarah played. Mom hugged and kissed Sarah. Mom gave Sarah 3 more mini Twix. Mom said it was her sister's birthday today. She is 42. She lives in Kansas right now. Mom said she will send her email to this versus Mom kisses and hugged Sarah. Mom and Sarah went around the room and popped all the balloons.
Why would the parent of a juvenile have to go on trial? What rights does a parent of a juvenile truly have in any court? I have something to tell you about the superior courts of the entire state of Washington. The judges have been misapplying the Juvenile Court Act to infants, toddlers, and children that are not juveniles. Despite the language throughout the act detailing juvenile rehabilitation, the judges I'm about to show you have been forcing parents into rehabilitation. Despite there being no reunification statutes within RCW 13.34. These judges and commissioners have been pretending that they have the power to terminate parents' rights by holding a trial, when reality is these are all agreed orders and not appealable. This is because a dependent child has no biological parents. Commissioner Jenny Laird recently retired, and this is a good thing because she is corrupt as hell. In 2014, this commissioner forced a 14-year-old child out of her mother's life for good, while she was parenting a newborn baby. This commissioner is paid a bonus incentive for every adoption that's completed under Title 40 federal funding. She has likely terminated the rights of thousands of parents illegally under the incorrect statutes 100% of the time, alleging dependency rather than child abuse or neglect. She has primarily destroyed the lives of Caucasian parents that don't have brown eyes in order to force their children into illegal adoptions. This commissioner will do anything for Natalie Green, the Secretary of DCYF. The judges in the superior courts in Washington state have also been targeting Ukrainian and Russian parents, due to their eye color being blue, to force their children into illegal adoptions, because that's the highest requested eye color from foster to adopt parents. The courts that these judges operate are public. All you have to do is sit in the courtroom for a few hours, and you will begin to see the unfair treatment of many parents regarding the custody of their children. These judges are absent all jurisdiction, unbelievable problem present for their crimes. The next judge is Janet Helson. She also pretends she has authority to hold trials. When these events are not authorized by statute, these parents are not defendants, they are parents of dependent juveniles, meaning they have no rights. The judges will ignore you when you question them, because they are immune from liability. But one thing they are not immune from, is being on YouTube like this. One thing they will not be able to ignore, is becoming infamous, and publicly exposed as a legal kidnapper. That is not a good title to have. If you work for the Department of Justice, any of the superior courts in the state of Washington, then you know exactly what I'm talking about. You see exactly what is happening, how infants are being unfairly removed and forced into involuntary servitude for the rest of their childhood. When I find out what your name is, I'm going to put you on YouTube just like these judges. I'm going to tell the world what you are doing, and who you are helping. Judge Janet Helson favors parents based on their nationality. She treats Caucasian parents without brown eyes 10 times worse than other parents. Judge Adrienne McCoy is her best friend. These judges know exactly what they are doing. They enjoy their job of terrorizing people who look just like them. These judges are blue-eyed robots, and they were sent to be sued, sent by Natalie Green, who was too scared to do the dirty work herself. There are hundreds of blue-eyed robots in King County and across the state. They were not hired for their credentials, but rather their physical traits of not having brown eyes. Every person involved in the trial on this channel does not have brown eyes. If you are a parent in the state of Washington who is stuck in Child Protective Services court hearings and can't get your children out of foster care, just remember signing and agreeing to these orders is the equivalent of giving your children to them. They will pretend as if your signature doesn't matter, but the government needs your permission to have your child in a foster home. Because if you think about it, they're alleging dependency, meaning they're not alleging child abuse or neglect, so they have to have your signature. They will get mad at you for not signing, they may even retaliate. But participating in their court may do more harm than good, that is if your eyes are not brown. This is simply due to Child Protective Services being more of a child adoption agency than a child protection agency.
The Supreme Court has long recognized as a component of substantive due process the right to familial relations. We recognize the constitutionally protected liberty interests that parents have in the custody, care, and management of their children. This primary role of the parents in the upbringing of their children is now established beyond debate as an enduring American tradition. The Due Process Clause includes a substantive component that provides heightened protection against government interference with certain fundamental rights and liberty interests. These decisions recognize that the right of a man and woman to marry, and to bear and raise their children is the most fundamental of all rights, the foundation of not just this country, but of all civilization. Equally fundamental is the substantive due process right of a child to be raised and nurtured by his parents. Until the state proves parental unfitness, the child and his parents share a vital interest in preventing erroneous termination of the natural relationship. We recognize that the forced separation of parent from child, even for a short time, represents a serious infringement upon both the parent's and child's rights. A child's right to family integrity is concomitant to that of a parent. Thus, substantive due process provides the appropriate vehicle for evaluating the constitutionality of the nearly 4-month government forced separation of CA from his parents. It is evident that there was interference with plaintiff's rights of familial association because LB was physically removed from her home and from her parents for a period of almost 18 hours, which included an overnight stay in a prearranged shelter home. The Due Process Clause of the 14th Amendment prohibits the government from interfering in the familial relationship unless the government adheres to the requirements of procedural and substantive due process. It is possible to state both a procedural and substantive due process claim, holding that a single act of depriving a citizen of his right to correspond may simultaneously constitute a violation of substantive constitutional right and of the right to procedural due process. Therefore, the defendant's actions toward CA may simultaneously constitute a violation of his substantive due process rights if his removal was not justified by a sufficiently compelling governmental interest, and his right to procedural due process if the manner in which the deprivation occurred violates procedural norms. The Due Process Clause of the 14th Amendment prohibits the government from interfering in familial relationships unless the government adheres to the requisites of procedural and substantive due process. In this case, CA alleged a liberty interest in his familial relations. This is a protected liberty interest. Thus, we must consider what process was due. The Supreme Court has said that parental rights cannot be denied without an opportunity for them to be heard at a meaningful time and in a meaningful manner. Similarly, a child's right to be nurtured by his parents cannot be denied without an opportunity to be heard in a meaningful way. What exactly this means is less clear, as the amount of process due varies with the particular situation. It is a flexible concept. However, no matter how much process is required, at a minimum it requires that government officials not misrepresent the facts in order to obtain the removal of a child from his parents. An ex parte hearing based on misrepresentation and omission does not constitute notice and an opportunity to be heard. Minimally, it also means that governmental officials will not remove a child from his home without an investigation and pre-deprivation hearing resulting in a court order of removal, absent exigent circumstances. Removal of children from the custody of their parents requires pre-deprivation notice and a hearing except for extraordinary situations where some valid governmental interest is at stake that justified postponing the hearing until after the event. A parent has a liberty interest in familial association and privacy that, absent extraordinary circumstances, cannot be violated without adequate pre-deprivation procedures. When a child's safety is threatened, that is justification enough for action first and hearing afterward. Only where a child's life is in imminent danger or where there is immediate danger of severe or irreparable injury to the child's health and prior judicial authorization is not immediately obtainable may an official summarily assume custody of a child from his parents. Although the touchstone of the 1983 action against a government body is an allegation that official policy is responsible for a deprivation of rights protected by the Constitution, local governments, like every other 1983 person, by the very terms of the statute, may be sued for constitutional deprivations visited pursuant to governmental custom, even though such a custom has not received formal approval through the body's official decision-making channels. As Mr. Justice Harlan, writing for the court, said in Addicts v. S.H. Cress, Congress included customs and usages in 1983 because of the persistent and widespread discriminatory practices of state officials. Although not authorized by written law, such practices of state officials could well be so permanent and well settled as to constitute a custom or usage with the force of law. It is not necessary, at the pleading stage, to be able to identify with particularity the who, what, where, when, and how of a claim. See Twombly. What is necessary is simply enough to put the defendant on notice as to the theory of liability and to state a plausible claim for relief. See Starr v. Baca. In re-guardianship of DJ, we observe that both parents and their children have a recognized unique and legal interest in, and a constitutionally protected right to, companionship. In other words, the substantive due process right to family integrity protects not only the parent's right to the companionship, care, custody, and management of his or her child, but also protects the child's reciprocal right to be raised and nurtured by his or her biological parent. It is clear, therefore, that both parents and their children have cognizable substantive due process rights to the parent-child relationship. See Amanda C. vs. Case, 2008. Liability for negligently inflicted harm is categorically beneath the threshold of constitutional due process. Croft assessed liability when a social worker acted to separate parent and child without any valid basis for doing so. In other words, decision-making by a social worker that is so clearly arbitrary, as was that in Croft, can properly be said to shock the conscience and, therefore, violates the substantive due process rights of the affected family. Thus, to the extent that appellants claimed a violation of their due process rights because Scheer acted negligently or lacked objectively reasonable grounds to pursue the case against them and their appeal indeed focuses on this issue, they did not state a valid claim. See Miller v. City of Philadelphia, 1999. Plaintiff may seek damages against state official defendants in their personal capacities. Second, state officials are persons under Section 1983 when sued for prospective injunctive relief. This exception for prospective injunctive relief, called the Ex parte Young Doctrine, applies where a plaintiff alleges an ongoing violation of federal law, and where the relief sought is prospective rather than retrospective. Where the plaintiff is seeking damages against a state official, a strong presumption is created in favor of a personal capacity suit because an official capacity suit for damages would be barred. The Supreme Court has developed 4 different tests that aid in identifying state action: 1 public function, 2 joint action, 3 governmental compulsion or coercion, and 4 governmental nexus. See Pasadena Republican Club vs. W. Just. Center, 2021, quoting Rawson vs. Recovery Innovations, 2020. As such, when a state actor casts doubt on an individual's good name, reputation, honor, or integrity in such a manner that it becomes virtually impossible for the individual to find new employment in his chosen field, the government has infringed upon that individual's liberty interest to pursue the occupation of his choice. Holding mother and children had actionable claim when state removed children from home and refused to return them without due process of law. See Duchesne vs. Sugarman, 1977. Holding that a single act may constitute policy, if a final policymaker officially sanctioned or ordered the act, regarding which there were no policies not of that official's making constraining the decision. Williams vs. City of Allentown. Holding that the plaintiff failed to allege an informal policy, in part because the plaintiff did not contend that the allegedly unconstitutional action was ever directed against anyone other than himself. Holding that state law determines whether a particular official has final policymaking authority. Holding that only those municipal officials who have final policymaking authority may by their actions subject the government to Section 1983 liability. See Denman vs. City of Tracy. The Supreme Court has cautioned that the Due Process Clause does not purport to supplant traditional tort law, and therefore it should not be interpreted to impose federal duties that are analogous to those imposed by state tort law. Collins vs. City of Harker Heights. Judicial immunity for state defendants does not extend to actions for prospective injunctive relief. See Morales vs. Waco. Claims for injunctive and declaratory relief are unaffected by qualified immunity. Heydrich vs. Hunter, 2012. Holding that compensatory damages include actual losses, mental anguish and humiliation, impairment of reputation, and out-of-pocket losses. See Barunda, 1389, Knudsen vs. City of Ellensburg, 1987, Chalmers vs. City of Los Angeles, 1985. Municipalities can be held liable for compensatory damages. See Owen vs. City of Independence. Pro se litigants are entitled to recover actual costs reasonably incurred to the extent that an attorney could have received these costs under a Section 1988 attorney's fees award. Burt vs. Hennessy. When resolving a motion to dismiss for failure to state a claim, a district court may not consider materials outside the complaint and the pleadings. See Gumadodo vs. DIR of Department of Revenue and Taxation. To be clearly established, the contours of the right must be sufficiently clear that a reasonable official would understand that what the official is doing violates that right. Anderson vs. Creighton. Where a private party conspires with state officials to deprive others of constitutional rights, however, the private party is acting under color of state law. See Tower vs. Glover, 1984. To prove a conspiracy between the state and private parties under Section 1983, the plaintiff must show an agreement or meeting of the minds to violate constitutional rights. To be liable, each participant in the conspiracy need not know the exact details of the plan, but each must at least share the common objective of the conspiracy. United Steelworkers of AM versus Phelps Dodge Corp. 1989. In light of this extensive precedent, it cannot now be doubted that the Due Process Clause of the 14th Amendment protects the fundamental right of parents to make decisions concerning the care, custody, and control of their children. Troxel versus Granville. The police cannot seize children suspected of being abused or neglected unless reasonable avenues of investigation are first pursued, particularly where it is not clear that a crime has been, or will be committed. Whether a reasonable avenue of investigation exists, however, depends in part upon the time element and nature of the allegations. Croft versus Westmoreland County Children and Youth Services.